Thank you so much. It's my pleasure to be here. Okay, this is a picture I took this morning. It's in front of my hotel here in Brussels. As you can see, this is a bookstore with the signs only written in English. All the commercial information from outside is also written only in English. Here you can see, for instance, the opening hours. And as far as I know, this is completely legal here in Brussels. In fact, I have seen many other shops like that. However, this wouldn't be possible, this wouldn't be legal in my hometown in Barcelona. The owner of this store would be probably sanctioned with a fine up to 10,000 euros. Well, Catalan legislation on consumers and language policy establishes a wide range of linguistic obligations on owners of stores and commercial establishments in Catalonia. For instance, the duty to provide written and oral attention in Catalan, if clients require to, the duty to provide in Catalan labeling, instruction of products, contractual information, or even the duty to display signs, posters, offers, handwritten information in blackboards, both indoors and outdoors in Catalan. A failure to comply with these provisions results in the imposition of fines, as I have mentioned, up to 10,000 euros. And data show that Catalan regional authorities make an intense, increasing use of this sanctioning power. Well, to properly understand the legal consequences or questions at stake, three remarks must be made from the very beginning. The first one, according to the Spanish Constitution, Spanish Castilian is the official language in the whole territory of Spain, since it is the common language for all Spaniards. There are also other Spanish languages that can be official in some parts of the territory if the law establishes so, and this is, for instance, what has happened with the Catalan language in Catalonia. Spanish Constitution establishes as well an express duty to know Catalan for all Spaniards. This means that public powers are prevented from imposing the duty to know any other language, and that they are also prevented from assuming that citizens know any other language than Spanish. Second remark, linguistic obligations imposed by Catalan law are not based on the regulation of the officiality of Catalan language in Catalonia. And the reason for that is very simple. Regulation of officiality applies only to vertical relations between citizens and public powers, public authorities, but does not apply to horizontal relations between two individuals, two private parties, a client and a businessman, for instance. This means that the right of citizens to a linguistic choice is a right of the citizen in front of public powers, and that the duty to linguistic availability is a duty for public powers, but not for private individuals. Third remark, these obligations imposed by Catalan law are not based on the protection of public health, safety, or economic rights of consumers in Catalonia. All Spanish clients, and therefore all Catalan clients alike, speak Spanish, since they have the constitutional duty to know it. Accordingly, the protection of Spanish and Catalan clients is only ensured by requiring that commercial and contractual consumer information be published and displayed in Spanish. Two ideas follow from this, very crucial ideas. The first one, the obligation of that information be also in Catalan contributes nothing to consumer protection, and for that reason, it would be a disproportionate restriction. Second one, the obligation of that information be at least in Catalan would violate the rights of consumers and clients in Catalonia because they do not necessarily understand or speak Catalan. Taking all this into account, I think we can state that these measures we're talking about are clearly discriminatory on grounds of language. They are discriminatory for Spanish-speaking clients in Catalonia compared to Catalan-speaking population. Neither are Catalans required to know Catalan, nor can public authorities presume they do so. Consequently, Spanish-speaking clients may not be able to understand the information provided or displayed in Catalan, unlike the Catalan-speaking population. They are also discriminatory against Spanish-speaking businessmen and owners of stores and establishments in Catalonia, as establishing and managing their business is more burdensome for them than for Catalan-speaking individuals. As they are not Catalan speakers, they are required to hire the translation services or staff to comply with these obligations. Certainly, Catalan legislation does not prohibit the additional use of Spanish or any other language in commercial relations.
Να μιλάτε λίγο πιο σιγά για να προλαβαίνουν οι μεταφραστές. Slow.
Okay, sorry. Certainly, Catalan legislation does not prohibit the additional use of Spanish or any other language in commercial relations. Certainly, a business owner could freely decide to provide and display all information in addition to Catalan in Spanish or in any other language. But even in that case, imposing the use of Catalan clearly places Catalan-speaking population in a better position than the non-Catalan-speaking population. And I think we all may agree that among the non-Catalan-speaking population in Catalonia, what we find most is Spanish-speaking population. Therefore, linguistic obligations imposed by Catalan legislation result in an indirect discrimination primarily against the Spanish-speaking population. However, these discriminatory measures might be acceptable if they meet some requirements. First one, they must be established by law. I think I'm here. And they are, since they have been adopted by the Catalan Parliament. Second one, they must have a legitimate objective, and they have it, since it has been accepted that the lawmaker can regulate private relations or relations between private individuals with the objective of promoting and fostering a language. And the third one, which is the key point, is that these measures must satisfy the proportionality principle. As for the duty to attend orally and in writing in Catalan, well, the decision on the language a person uses to communicate falls clearly within the core of the freedom of language and the free development of personality. It seems, therefore, difficult to accept that the promotion of a language can prevail over such fundamental freedoms. There are other measures, equally effective and much less restrictive, to achieve the same goal of promoting and fostering a language. And consequently, the imposition of such an obligation must be considered disproportionate. As for the obligation to display signs, posters, and other information, both indoors and outdoors in Catalan, well, from a purely economic perspective, it seems clear that not all obligations are equally burdensome. The imposition of the use of Catalan on interior signs, posters, or any type of documents or information clearly constitutes an excessive burden and therefore has a disproportionate impact on the freedom to conduct a business. Moreover, this requirement makes it excessively difficult for a service provider to establish in Catalonia. And this, again, represents a disproportionate impact on the constitutional principle of market unity, if we talk about the territory of Spain, but also on the free movement of services, workers, and freedom of establishment within the European internal market. On the contrary, exterior signs, they are based, fixed, stable elements, they represent a smaller economic burden, and therefore, from the solely perspective of the economic dimension, the obligation to display them in Catalan could be proportionate. However, the analysis of exterior signs cannot be limited to the purely economic dimension. The exterior signs of a business or an establishment are closely linked to how the individual, the business owner, wants to be seen and presented in front of the world. And from this perspective, the name of my business and the language I use or choose to express it has a very significant impact on individual freedoms, freedom of language, free development of personality, freedom of expression, even freedom of artistic creation. And just as an example, consider businesses that are centuries old or decades old or have belonged to a family with that very name and that very denomination in Spanish for several generations. Well, all these must be considered when balancing the sacrifice of individual rights and the promotion of the language. And again, there are measures that are equally effective and much less restrictive to achieve the same goal. Consequently, the imposition of a general unconditional duty or obligation to display exterior signs in Catalan must also be considered disproportionate. In conclusion, my analysis reveals that the discriminatory measures fail to comply with the proportionality principle, and therefore they cannot be considered justified. They treated Spanish speakers, both consumers and business owners, in a discriminatory manner on grounds of language. And this leads to a violation of the principle of non-discrimination and linguistic diversity laid down in Article 21 and 22 of the Charter. This has to be put in connection with other fundamental rights that are also violated: freedom of language, free development of personality, freedom to conduct a business, free movement of workers, freedom to provide and receive services, and freedom of establishment. Thank you.
Ευχαριστώ πολύ την κυρία Μεδάνια και η δεύτερη ομιλήτρια θα είναι η κυρία Στεφανή Λό, αναπληρώτρια καθηγήτρια Ευρωπαϊκού Δικαίου στο Πανεπιστήμιο του Southampton. Η κυρία Λό θα εξετάσει τις νομικές συνέπειες της καταλανικής νομοθεσίας όσον αφορά τα δικαιώματα των καταναλωτών και την επεσήμανση των προϊόντων. Αγαπητή κυρία Λό, έχετε 10 λεπτά για την παρουσίασή σας.
So firstly, thank you very much for the opportunity to speak before the committee this afternoon on the topic of the assessment of the legal consequences of the provisions of the Catalan Consumer Code on language and the EU consumer protection regime. From the perspective of the compliance of Article 1281 of the Consumer Code, and in particular Article 12812, of that code, which establishes that consumers are entitled to receive, thus establishing an obligation on businesses to provide certain information in Catalan with EU consumer law, three key questions arise. The first is whether these provisions of the Catalan Consumer Code requiring the provision of information to consumers in Catalan are compliant with EU law principles of consumer protection, particularly in the Consumer Rights Directive of 2011, 83 EU. The second question, whether the provisions are compliant with the objectives of consumer protection broadly, including, as was introduced previously, equality of protection of consumers. And thirdly, whether the information obligations established in the Catalan Consumer Code offer a suitable level of protection to both Spanish speakers and non-speakers of Catalan on the territory of the autonomous community of Catalonia. Firstly, I will very briefly set out the framework of EU consumer protection law, including its aims, objectives and legal bases. Thereafter, examine the role of information in EU consumer law, particularly under the Consumer Rights Directive. And finally, draw conclusions in relation to the three questions that I've just set out on the compliance of the provisions of the Catalan Consumer Code with the EU consumer protection regime. So consumer protection is established as an objective both of the Union and of its member states, being a shared competence per Article 4(2)(f) of the Treaty of the Functioning of the EU, in various provisions of primary and indeed secondary EU law. It's inherently tied to the establishment of the internal market. This is clear predominantly from the legal basis for legislating for consumer law, primarily Article 114 TFEU, as well as the complementary legal basis found in Article 169 TFEU. While Article 169 establishes that the Union shall contribute to protecting the health, safety and economic interests of consumers, as well as to promoting their right to information, education and to organise themselves in order to safeguard their interests. Most consumer law, most EU consumer legislation, including the Consumer Rights Directive, finds its basis in Article 114. Article 114 refers to the approximation of national laws to the ends of the establishment and functioning of the internal market. Consumer protection should also be taken into account in the development of EU law broadly, per Article 12 TFEU, and in accordance with Article 38 of the Charter of Fundamental Rights of the EU, which provides that union policies shall ensure a high level of consumer protection. It's worth noting that EU consumer law has developed predominantly, although not exclusively, by means of positive integration. That is primarily and in accordance with Article 288 of the Treaty of the Functioning of the EU. It has been adopted predominantly in the form of directives, which must then, of course, be implemented into the domestic legal regimes of the member states, establishing substantive and only recently, and indeed to a very limited extent, procedural rights for consumers. It's further worth noting that EU consumer law is fragmented and sectoral, there being over 20 or so pieces of secondary law, again primarily directives, governing consumer relationships and of general application, including distance selling contracts, unfair contract terms and commercial practices, consumer credit, as well as product labelling rules applicable to specific products, including cosmetics, toys, medicines, and food products. Consumer law conceptualises, on the one hand, consumers as rational economic actors who can exercise self-determination on the market. On the other hand, however, it's recognised that information and power asymmetries between consumers and traders undermine the freedom of contract and autonomy that should, in principle, allow for the exercise of such choice. Information is thus the key mechanism employed in EU consumer law to correct these asymmetries, and we can see the significance of information as this mechanism in the Consumer Rights Directive itself. Consumers should be afforded accurate, clear and consistent information to make choices on the market. As such, Articles 5 and 6 of the Consumer Rights Directive establishes information obligations for traders in respect of consumer contracts. Those provisions, namely Article 5 and 6 of the directive...
Sorry, speak slow.
Sorry. Namely Articles 5 and 6 of the directive oblige traders to provide consumers with certain information set out specifically in those provisions, and including, for example, information on the main characteristics of the goods or services provided, the identity of the trader, price, and any right of the consumer to withdraw from that contract. Fundamentally, this information should be provided in a clear and comprehensible manner if that information is not otherwise easily understood from the context. It essentially establishes that that information should be easily understood by the consumer. As regards the compatibility of the provisions of the Cataluñan Consumer Code with EU consumer law, Member States, as we've heard, are free to make provision for the use of language within their territory, and that those linguistic regimes established may operate for the purposes of promoting linguistic security, but also, or in addition, for consumer protection purposes. It's worth noting that the Consumer Rights Directive, 2011-83, makes little provision on linguistic requirements. It essentially maintains this principle of national sovereignty as regards the establishment of linguistic regimes in both its Recital 15 and Article 6(7). The directive does not harmonise language requirements in relation to consumer contracts, thus allowing member states to either maintain or to introduce language requirements in order to ensure the information provided by traders is easily understood by consumers. However, secondary EU law, including, for example, directives on product labelling, may provide that information is indeed to be provided in more than one official language of a member state. Where this is not done in accordance with the directives and by virtue of the transposition of that directive into domestic law, the member states will be in violation of EU law. The European Court of Justice in 2021 came to this conclusion. However, the Consumer Rights Directive in and of itself makes no such provision in relation to language. The Consumer Rights Directive in and of itself does not preclude provisions such as those found in the Catalan Consumer Codes. As such, looking to the first question I set out, it's likely these provisions would be compliant with that particular directive. However, national law may conflict with primary or secondary EU law as regards the development of the internal market. On the one hand, linguistic regimes within member states may impede free movement rules, where there is a cross-border element, as my colleague later will discuss, for example, precluding or undermining business opportunities to market products on the EU internal market, and thus constitute barriers to trade. On the other hand, these national provisions may undermine the equality of consumer protection, both within and across EU member states. For example, if a national obligation is to provide information only in one language, which precludes the provision of that information to consumers in a clear and comprehensible manner. In each of these instances, the provision of language, which may otherwise A, constitute a barrier to trade, or B, entail discriminatory consequences, could in fact be just, notwithstanding that they constitute a barrier to trade or entail discriminatory consequences, there is a possibility that these provisions of national law could be justified. Looking firstly to provisions which constitute a barrier to trade, if the language provisions would have an effect on free movement, then the rule would have to be justified. Consumer protection could operate as a legitimate ground to justify a restriction on free movement. That rule, however, of national law would also have to be necessary and proportionate to achieve the intended objective. Proportionality here is key. There is consistent case law of the European Court of Justice to suggest that it's sufficient that information is provided to consumers in a language that can be easily understood by consumers within a particular territory. That's to say, in a bilingual or multilingual context, that the information is provided in the state's official language, rather than in the regional language, would fulfill the requirement, the objective to the ends of consumer protection, of that information being easily understood. As to the second possible outcome, that is the potential discriminatory nature of the language provisions in the Cataluñan Consumer Code, information provided in a language not spoken or otherwise understood in that country might indeed be precluded on the grounds of consumer protection, in that they undermine consumer protection objectives, and that they discriminate against certain consumers, i.e. non-Catalan speakers within Spain, undermine several fundamental rights, including Articles 21 and 22, as well as Article 38 of the Charter of Fundamental Rights. In this instance, as the previous speaker indicated, it must be ascertained whether these effects can be justified, in that they have been adopted by law, they pursue a legitimate interest, and that they satisfy the test of proportionality. As the previous speaker has already established, the protection of consumer interest cannot constitute a legitimate objective for the purposes of imposing these restrictions, as there is no duty to know Catalan. As such, the consequences of the application of the linguistic provisions in the Consumer Code, both as to the extent that they constitute barriers to trade and to the extent that they undermine the principle of equality of consumer protection, likely cannot be said to be proportionate. Thank you.
Ευχαριστώ την κυρία Λό για την παρέμβασή της. Η επόμενη ομιλήτρια είναι η καθηγήτρια Ελεονόρ Σπαθέντα, η οποία διδάσκει δίκαιο της Ευρωπαϊκής Ένωσης στη νομική σχολή Άντζελο Σαραμάν του Πανεπιστήμιου Μασκόνη του Μιλάνου, της Ιταλίας. Είναι επίσης επισκέπτρια καθηγήτρια στο Κολέγιο της Ευρώπης στην Πρίζ του Βελγίου. Η κυρία Σπαβέντα θα εξετάσει τις νομικές και οικονομικές συνέπειες της καταλανικής νομοθεσίας όσον αφορά την ελεύθερη κυκλοφορία αγαθών και υπηρεσιών. Η κυρία Σπαβέντα συμμετέχει σήμερα εξ αποστάσεως. Αγαπητή καθηγήτρια, έχετε τον λόγο για 10 λεπτά.
Thank you very much. Thank you for having me, and I apologize for having to be online rather than in person, but I couldn't do otherwise. So I was asked to assess the compatibility of those rules with the general treaty provisions of goods and services, and my colleagues have already touched upon the main legal problems that we see in this field. So first of all, we should remember that linguistic diversity is a constitutional value in the European Union. It is protected by several rules in the treaties. Article 3.3 of the Treaty on the European Union mentions the duty of the EU to respect linguistic diversity. Article 4.2 provides for the need to respect national identity, and the court has made clear that even the protection of non-official languages is part of that national constitutional identity. Article 21 and 22 of the Charter protect Article 21, the right not to be discriminated on grounds of language. Article 22, linguistic diversity. And Article 165 provides the respect of linguistic diversity in education. And Article 207 changes the majority required in relation to audio media services agreements with third countries. So if we could have the first slide, please. Yeah, thank you very much. But as we said, and my colleagues have already said, these constitutional rules, so this constitutional value needs and must be balanced with other constitutional rules and constitutional values in the European Union, and especially for what we are concerned with the treaty free movement of goods provisions and the treaty services provisions. Now, in order for a situation to fall within the treaty provisions, there are some preconditions that need to be established. First of all, the free movement provisions only protect situations where there is a cross-border link, which means in our case that those situations must regard either the import or the export of goods or the cross-border provision of services. Secondly, in order for a situation to fall within the treaty, you need to establish that the rule that is contested constitutes a barrier to the import or export of goods or cross-border provision of services. It is only when these two conditions are satisfied that the rule will have to be justified. In our case, as my colleagues have already mentioned, the two grounds for justification would be the need to protect the language and linguistic diversity in the European Union, which, as I said, is a constitutional value of the European Union, and or the need to protect the consumer. The court has accepted that these are grounds for that might justify a restriction, but it has also said that the rules need to be necessary and proportionate, as already mentioned by my colleagues, and furthermore, the rules need to be compatible with the Charter. So with that provision that I mentioned earlier about non-discrimination on grounds of language, but also with the freedom of expression and the freedom to conduct a business. Now, when we go and look at the rules that we are considering, there is a difference. Can I have the next slide, please? A difference between those rules that concern the signage and those rules that concern the mandatory provision of information in Catalan. In relation to the rules concerning signage, a cross-border dimension needs to be established, and this is more difficult to be established in the case of the free movement of goods, and this is because of a case law of the Court of Justice established starting from 1993. So for a restriction on the cross-border goods provision to exist, we would have to prove that there is an effect on the access to the market of imported goods. And this is because, as I think was mentioned before, this is a static requirement. It is not to be excluded that that could be the case. For instance, if the signage was linked to a particular product that is imported, for instance, a product that is better known in English, computer, or if the goods were directed at particular customers that would not understand the signage in Catalan. But according to the case law, it is more difficult in these situations to establish a cross-border dimension with the import of goods. In relation to services, it would be easier to do so because actually the case law of the court has clarified that even if the service is provided within the territory, if the recipient of the service is not established in that territory, then that satisfies the requirement of the cross-border nature. So to give you an example, if I advertise or I want to target tourists, that would be a cross-border service because I am targeting people who do not reside within that given member state or are most likely not to reside there. Now, once you establish a cross-border dimension, you must justify the rule as it was mentioned, and in the case of the justification, we said it must be necessary and proportionate. Here, language requirements would not be justified on consumer protection grounds because it would be enough for the language to be easily understood by consumers, as mentioned by my colleagues. Language protection would be to a certain extent easier to justify in these cases, but it would need, the justification would need to fulfill a strict proportionality requirement. And so the balancing would be between the restriction imposed on the economic operator and the need to promote language usage in a certain region. In any case, a double signage must be allowed, and I think our colleague has already mentioned that this would be allowed. More difficult to justify, next slide please, would be the need to provide documentation in Catalan. First of all, in this case, it would be fairly easy for anyone who also sells imported goods or provides services to someone who is established outside of Spain to establish this link with cross-border. Furthermore, these rules would have an internal partitioning effect because an imported product, for instance, would need to have the documentation both in Spanish and in Catalan. And this would be a double requirement and would impose significant cost and effort on those importing those goods, and similarly with services. As far as the justification is concerned, again, we're talking about language protection and consumer protection. As I said, because of the partitioning effect of these rules, it would be fairly difficult to justify them, because you would need, in weighing up the restriction and the interest pursued, you would need to achieve the proper balance. For this reason, if the language used could be easily understood by the consumer, then an additional language could not be imposed, and even if the interest invoked was that of the protection of and promotion of the language, it would be very difficult because of the effects. The court has been somehow receptive to the sensitivities of the member states, but in any case it has excluded or it has requested states, even when they impose their own regional languages, to traders or service providers to show flexibility when the situation is cross-border, either because of the import of goods or the cross-border provision of services. Thank you very much.
Σας ευχαριστώ, κυρία Σπαθέντα, για την παρέμβασή σας. Θα ήθελα τώρα να δώσω το λόγο στους βουλευτές για τις παρέμβασεις τους με τη σειρά που προβλέπει το πρωτόκολλο. Παρακαλώ, κύριοι συνάδελφοι, λάβετε υπόψη ότι ο χρόνος ομιλίας για κάθε βουλευτή είναι 2 λεπτά. Θα ξεκινήσουμε από το EPP και την κυρία Εστάρας.
Sí, muchas gracias por la organización de este workshop. Muchas gracias también a los ponentes. Efectivamente, en Cataluña, a la raíz de toda la información que tenemos y las peticiones que se han volcado en esta comisión, hay una discriminación clara en relación a la imposición de la lengua catalana en todo lo que es la rotulación de los comercios y en las inspecciones que se hacen a estos comercios por parte de unas comitivas de voluntarios que se dedican a, sin ningún cargo en la Administración, pero se trata como de una especie de comandos ciudadanos independentistas que van vigilando todos los comercios, les van, entre comillas, no sugiriendo, sino casi compeliendo a que tienen que ponerlo todo en catalán y además pues explicándoles que tendrán sanciones si no lo hacen. Automáticamente estos comandos ciudadanos independentistas volcan esta información, estas denuncias a la Administración, que impone pues las respectivas multas y sanciones. Lo que es muy importante, y hay que decirlo aquí, es que la ley y el sentido común obligan a que la lengua sea un vehículo de comunicación. Siempre, yo provengo de las Islas Baleares, amo profundamente mi lengua catalana propia de las islas, pero la manera de amar la lengua es nunca imponerla ni prohibirla, sino que es hacer lo que hacemos en mi tierra, que es practicar el bilingüismo cordial. Cuando se impone, y se impone de esta manera, además de atacar a todas las libertades, al principio de no discriminación, a la protección al consumidor, a la libre circulación de bienes y servicios, de verdad que se hace un flaco favor a la lengua. las administraciones públicas lo que tienen que hacer es crear las condiciones óptimas para que las actividades económicas se desarrollen facilitando esas actividades empresariales. Entonces, el mecanismo de imponer no es el mecanismo que toca y, sobre todo, lo más importante, las autoridades tienen que cumplir las sentencias judiciales. No lo hacen en el caso de la educación. Hay una sentencia del Tribunal Supremo que obliga al 25% al menos en la lengua española. Y tampoco lo hacen en este caso. Las sentencias hablan de que sí, los rótulos pueden ser en catalán, pero tiene que haber disponibilidad lingüística, porque hay una lengua que nos une a todos, que es el español, y no solamente no se hace, sino que se hace todo el camino contrario. Pues por lo de aquí un llamamiento a las autoridades catalanas. El problema es cuando la lengua se ideologiza y se convierte en un instrumento del independentismo. Cuando esto pasa, significa que el independentista no ama la lengua, la hunde, porque la utiliza ideológicamente. Cuando algo lo quieres de verdad, como lo quiero yo, nunca ideologizaría mi lengua, porque la lengua es un bien de todos y es un bien para comunicarse. Y la grandeza de la lengua es utilizarla de acuerdo con la ley y de acuerdo de que sea un vehículo de comunicación, a que sea una apelación a cumplir con el sentido común y con las sentencias judiciales. Gracias.
Ευχαριστούμε πολύ. Το λόγο έχει τώρα από τους Patriots για την Ευρώπη ο κύριος Μποξάιτ, αν το λέω σωστά, συγγνώμη.
Pues muchas gracias, presidente, y por supuesto muchísimas gracias a los tres intervinientes. No es habitual que tres especialistas de tres países distintos, nacionalidades distintas y trabajando en ámbitos distintos alcancen la misma conclusión. Y esto yo creo que es lo más importante. Desde tres ópticas distintas, una más constitucional española y las otras dos visiones más desde el derecho de la Unión Europea, llegan a la conclusión de que hay una evidente vulneración de los derechos lingüísticos en Cataluña. Yo también nací en Cataluña, yo también nací en Barcelona y, por tanto, soy conocedor de la realidad social. Quiero también poner de manifiesto que en esta misma Comisión de Peticiones se elaboró un informe al respecto de la vulneración de los derechos lingüísticos en las escuelas en Cataluña, tras una misión en la pasada legislatura, y uno de los elementos de esas conclusiones, en la que había una recomendación de la Comisión de Peticiones que sigue sin cumplirse, coincidía exactamente en el ámbito lingüístico con lo que sucede en el ámbito comercial. Y es, por ejemplo, que las páginas web de todos los colegios en Cataluña exclusivamente están en catalán y no en español, vulnerando, se decía en aquel momento por la Comisión de Peticiones, los derechos de los padres y de los propios alumnos. Creo que hay que poner de manifiesto que uno de los principios fundamentales de la Unión y una de las piezas fundamentales del modelo es la libertad. Y el modelo lingüístico que se ha impuesto en la Comunidad de Cataluña es sustancialmente totalitario. Mi compañera del Grupo del Partido Popular ha hablado de grupos de voluntarios. Yo creo que son grupos totalitarios. Les falta poner la estrella de David en la puerta de los comercios que no publican su cartelería en español. Estamos hablando de organizaciones pagadas, subvencionadas por el propio gobierno regional, que se destinan o que dedican parte de su trabajo a señalar a los empresarios, a los autónomos, a las empresas. Yo creo que es muy importante, aunque no estamos propiamente en un momento de solicitar acciones, que por parte de la región de Cataluña se nos informase de cuántos expedientes sancionadores se han iniciado contra empresas en Cataluña al respecto de esta cuestión. ¿Cuántos pequeños empresarios, autónomos o incluso medianas empresas han sido sancionadas? ¿Cuántas de esas empresas incluso no tienen su domicilio social en Cataluña? Somos perfectamente conocedores de empresas que trabajan desde Madrid, que celebran contratos con consumidores en Cataluña y que se les obliga a la empresa radicada en Madrid a hacer los contratos en catalán. Se afecta, se ha dicho aquí por los expertos, la libertad de pactos, la libertad de contratación, la libertad de prestación de servicios, de circulación y establecimiento. Vamos, el régimen de la Unión Europea. todo lo que justifica que se haya construido el modelo comunitario. Y, por supuesto, quiero hacer hincapié en una cuestión muy importante, porque además, y con esto voy a ir concluyendo, estamos supuestamente en la legislatura de la competitividad. Todos los grupos políticos hablan de competitividad, la Comisión Europea habla de competitividad, pues cómo se ataca a la competitividad de las empresas cuando se establecen, leo literal lo que se ha dicho por los expertos, restricciones y sacrificios injustificados a la libertad de empresa, a la libertad de contratación y a la libertad de publicidad. Por último, señalar que en Cataluña el catalán es lengua cooficial, que por tanto no hay ningún catalán que vea vulnerados sus derechos lingüísticos en sus relaciones con la administración pública, ni con la administración regional, ni con las locales, ni, por supuesto, ni siquiera con la administración estatal. Pero no se puede imponer a una empresa las mismas obligaciones que las propias administraciones asumen. A este respecto, la Carta Europea de Derechos Fundamentales dice: regirán las relaciones entre los ciudadanos y la Administración Europea, los ciudadanos y los Estados miembros cuando aplican legislación europea. Cuando una empresa rumana quiere operar en Cataluña, cuando una empresa de Sevilla quiere operar en Cataluña, no se le pueden imponer las mismas restricciones. En su consecuencia, pues simplemente agradecer de nuevo la calidad de los informes, la imparcialidad de los informes, la objetividad de los informes y, por otra parte, lamentar la situación de vulneración masiva, y ahora lo que procede es que busquemos los mecanismos para que los derechos vulnerados por los consumidores en Cataluña pues sean retornados al patrimonio de todos los catalanes. Gracias.
Ευχαριστώ, κύριε συνάδελφε. Από ό,τι βλέπω στην αίθουσα δεν υπάρχουν άλλοι βουλευτές. Θα παρακαλούσα από τους εμπειρογνώμονες, όποια θέλει να πάρει το λόγο έχει να προσθέσει κάτι για 3 λεπτά.
Thank you so much. Bueno, por responder al diputado Buxadé en relación a lo que ha planteado o lo que se ha preguntado sobre los expedientes o las sanciones que se han impuesto en Cataluña al respecto, los datos que a mí me constan de la propia Administración catalana solicitados a través de una petición de transparencia, bueno, ahora no los tengo aquí ahora mismo, pero denuncias, estoy hablando de los años 2017 a 2024, denuncias sí ha habido varios miles, aunque hay algunas, digamos, un poquito peculiares porque un mismo sujeto tiene más de 1000, dejando un poquito de lado esto. En cuanto a sanciones que se hayan impuesto efectivamente, lo que revelan estos datos proporcionados a través de transparencia son 220, creo recordar. Y la sanción prevista en la ley y varias de las que se han impuesto, por lo que yo he visto, son la máxima son 10.000 euros. Ciertamente la ley prevé que si se reincide pueden llegar a 100.000 euros, pero son 10.000 euros y las que yo he visto que se han impuesto en esta lista de 220, en varios casos, desde luego, han llegado a los 10.000 euros. Y son por varias de las... Si han visto la normativa, pues los incumplimientos pueden ser varios. Se puede incumplir cuestiones de etiquetado, de instrucciones, de atención, de rotulación externa, rotulación interna, un poquito de todo. Un poquito de todo. Simplemente esto. Gracias.
Ευχαριστώ. Κυρία Λό, έχετε να συμπληρώσετε κάτι?
No, I think what I wanted to add was already covered by my colleague. I suppose it's worth noting that in terms of the enforcement of EU consumer law, given the Union's relatively limited competence in the area of civil procedure, the enforcement of consumer law generally does fall to the member states in line with national domestic procedural law. So recital 57 of the Consumer Rights Directive provides for this. It's for the member states to ensure that the provisions of the directive are enforced and set out penalties for violations of those provisions. In accordance with Article 24 of the Consumer Rights Directive, as well as we'll find equivalent provisions in other pieces of EU consumer law legislation, including directives on product labelling and so on and so forth. There are limitations as to the implementation or imposition of those penalties. So penalties must be firstly effective in terms of remedying any harm caused from the perspective of consumer protection caused to the consumer themselves, proportionate in respect of the gravity of the violation, and dissuasive in terms of future violations. We can see, as my colleague indicated, that the Catalan Consumer Code does establish a regime for the application of the sanctions in I think Article 332(2) establishes a regime which differentiates between different types of offences under the Consumer Code. If I'm not wrong, violations of Article 1281, subsection 2, generally would constitute a minor offence, so which can be sanctioned by a fine of up to €10,000 and attributing both territorial and subject matter jurisdiction to a variety of different authorities within Catalonia. Thank you.
Ευχαριστώ. Κυρία Σπαβέντα, αν είναι ακόμα στη σύνδεση.
I think my mic is on. Thank you very much. Yeah, I have very little to add, but 2 points. One on something that is called reverse discrimination in EU law. So whereas I'm an EU lawyer, so I was focusing on the cross-border dimension, many jurisdictions provide that once a barrier is found for a importer, say, or a cross-border provider of services, then the rights that are granted by EU law need to be also provided for all economic operators. And this is to avoid discrimination against own nationals. And this is is often provided by national constitutional law. The second issue that I think is worth mentioning, just because one of the members of the European Parliament mentioned it, was the issue of contracts, and the court has already found that not to allow contracts in a different language, in that case the Belgian rules required the contract or the invoices to be drawn up in Dutch. And in this case, they were drawn up in Italian, so not even in the official language of where the business was established, because they were established in the Flanders. And the court found that because this was a contract between an Italian company and a Belgian company that was established in the Flanders, then that requirement was disproportionate. So language requirements in relation to contracts that are cross-border in nature really are very difficult to justify, because the important thing is that the parties to the contract can understand what they are signing for. Thank you.
Αγαπητοί προσκεκλημένοι, αγαπητοί συνάδελφοι, αγαπητοί συμμετέχοντες, εξ ονόματος της Επιτροπής Αναφορών, θα ήθελα να σας